come on to reasonable adjustments. What is reasonable? Who defines what's reasonable, first of all?
Well, who defines what's reasonable?
I promise I wouldn't ask Sharon that question, because
The
would you want to say why it's not for you?
Would you like to explain why it's not for you? Because your focus is...
Yeah, it really is a legal matter. The whole reasonable word, everybody in this room would have a different definition of reasonable. So we leave it down to the legal beagles and the law courts to say what they think against case law and the law itself.
I mean, in terms of what is reasonable is one of those words that's bandied about all the time, but what on earth does it actually mean? Well, unlike dismissal law, when you're looking at the law of reasonable adjustments, ultimately, if there's a dispute, it is literally for the tribunal to come in and determine what is reasonable, whereas in unfair dismissal law, a decision to dismiss and whether that is fair, the tribunal will look at whether the employer's decision was within a range of reasonable responses. So ultimately, in determining reasonableness, it is a question for, in our context, the employment tribunal.
So the tribunal says you were reasonable or you weren't reasonable in the steps that you actually took. If it decides you're not reasonable, it can award damages. Damages are, at least in theory, unlimited. So there's no cap on the amount of damages they can award.
That's correct.
But most people don't really want to wait until you get to tribunal to find out whether what they did was reasonable or not. So, good. Okay,
sure.
Thank you.
Yeah.
So what factors will a tribunal take into account? Well, the first and most important factor is, would the adjustment work? If you've got an employee who's suggesting adjustments which frankly wouldn't work to remove the disadvantage that they're suffering from in the workplace, there's no duty to make it. Is it practicable for the employer to make it is another issue. What's the financial cost to the employer or other cost to the employer? The employer's resources come into the equation, so a very large employer would be under a more significant obligation than a much smaller employer. And what are the nature of the activities that the employer performs? But the reason you can't give an answer in the abstract about A, what is reasonable, and B, what are the types of adjustment that are required, is that those questions depend upon the precise factual nature of the disadvantage that the impairment causes to that particular person in that particular workplace. So when I'm talking with an employer about what is likely to be considered by a tribunal as reasonable in this set of circumstances, what I do when I'm speaking on the telephone is really drill down to the nature of the impairment, the nature of what the person does, and what it is about what they're doing, and it's linked to the impairment that is causing that person a problem. But when you're thinking through, okay, what's reasonable, you're looking at, would it work, is it practicable, the financial and other cost, how will it affect other employees in the organisation, the nature of the resources they've got to throw at it, the cost, etc.